There were two, what I would call watershed moments under Act 195. And both of them had significant effect, not only on Act 195, but also on the relationship of collective bargaining in the state. The first was what we referred to as the State College decision, which took place in 1973. State College decision was an unfair labor practice filed by the State College Education Association against the State College School District. And the premise was that the school district was refusing to bargain certain items related to conditions of employment. Act 195 governs what is bargainable in the 700 sections of the Act. And Section 702 and 703 state, first in 702, that the employer cannot refuse to bargain wages, hours, working conditions. 703 says that the employer is not mandated to bargain that which is a matter of inherent management rights. The State College decision tested the difference between 702 and 703. Having filed an unfair practice, the association felt that the labor board would side with them, indicating that the items that they had on the bargaining table were mandated under Section 702. And there were about 25 items that the district had refused to bargain. And those 25 items were conditions of employment. They did not directly deal with salary or benefits. They dealt with such things as prep time, schedules, lunch duties, a myriad of conditions of employment which were quite important to folks in public education and which they wanted to memorialize in a contract. Quite to the surprise of everyone, the labor board ruled just about each one of those items to be inherent managerial prerogative. Thus, the first blow to bargaining took place in 1973, and that labor board order was appealed to the courts up to and including the Supreme Court. And each court sort of mitigated the effects, but clearly never ruled all of the items as bargainable. So there was a wet blanket placed by the court system on the ability to bargain items which were near and dear to the hearts of the employees, but also items which management would much prefer remained within their prerogatives. No one can underestimate the effect ultimately of the State College decision, because all but the strongest local associations who could prevail at the bargaining table on those items seemed to have a positive outcome. Most others were unable, even to this day, to successfully negotiate certain terms and conditions of employment. The lesson learned from the State College decision was that bargaining is something left best between the parties at the table, and if you can't accomplish what you need through bargaining at the table, wait for another day and don't submit your dispute to any third party, because you lose total control over what may happen to you. The second watershed moment of the act actually was the use of selective strikes as a tactic by locals throughout the state. A selective strike simply is a local association calling the cessation of classes or a strike at times of their convenience, and they would not necessarily be consecutive days. So a local association may declare a strike for the first, second, and third of the month, but say they're going back to work on the 4th. And they would give no more than 5 or 6 hours notice. This so outraged the public that opinion began to really swing the other direction. And eventually, the loss of public support for public employee bargaining, I think, was probably predicated on the use of selective strikes. That is not to say that they were not extremely effective for the employee organization. They were a balancing of power that would allow teachers to change the status quo sufficiently to force school boards to reconsider truculent positions at the bargaining table. Having lost, however, public support for strikes, the legislature in 1992 amended Act 195 and the school code by the adoption of Act 88. The basic difference between Act 195 and Act 88 was a transfer of power and initiative from the employee organization to the employer. And it was accomplished in a number of ways.